I'd like to call to order this meeting of the Standing Committee on Justice and Human Rights. We are going to be studying the Maine estimates today, and I am delighted that we're joined by our Minister of Justice, Jody Wilson-Raybould. Thank you for coming, Minister Wilson-Raybould. We're also joined by William Pentney, the Deputy Minister of Justice and Deputy Attorney General. Welcome, Mr. Pentney. And by Donald Paragoff, who is the Senior Assistant Deputy Minister in the Policy Sector. Welcome, Mr. Paragoff. I know that each of you is getting very familiar with coming before our committee. Probably you're enjoying it more and more each time, and we're delighted about that. And I will turn the floor over to Minister Wilson-Raybould for her opening statements.
Well, thank you, Mr. Chair. Good morning, everyone. I want to start off by acknowledging the territory of the Algonquin people, and certainly want to thank all members of the Justice and Human Rights Committee for the work that you have undertaken thus far and the agenda that you have in front of you. And also want to acknowledge Parliamentary Secretary Sean Casey and Bill Blair, who have been very helpful in assisting with respect to our mandate commitments and moving forward with them. So I'm pleased to appear before the committee this morning to answer questions about the 2016-2017 Maine estimates. And as you indicated, Mr. Chair, I'm joined by Bill Pentney and Don Paragoff, who will also be able to answer questions of committee members. So this past March, as you know, Deputy Pentney attended a meeting of this very committee and discussed the supplementary estimates. And I understand at that meeting that he provided an overview of the history and the mandate of the Department of Justice. And given that you are now already familiar with the business lines of the department, today I would like to talk to you about what I hope to accomplish in my role and my vision for how the Department of Justice will help contribute to the vision of an improved justice system with funds presented in these 2016-2017 Maine estimates. So through the 2016-17 Maine estimates, the department requested a total budgetary authority of $678.9 million. This represents an increase of $4.99 million from the 2015-16 Maine estimates. Of this total authority, $400.5 million will be dedicated to ensuring a fair, relevant, and accessible Canadian justice system, one of the department's strategic outcomes. Most of this funding is directed to the provinces and territories in support of the stewardship of the Canadian legal framework. In addition, as the primary legal services provider for the government, the department is seeking $199.6 million to continue to effectively support government programs. Mr. Chairman, one of my primary roles is to ensure that there is respect for the rule of law and that the Charter of Rights and Freedoms is upheld. This was a key part of my mandate letter from the Prime Minister. Equally important to me is ensuring that all Canadians have access to a fair, modern, and efficient justice system. And on March the 21st, the government revealed its spending plan for the 2016-2017, which contains measures that will help Canadians assert their rights and provide disadvantaged Canadians with access to our justice system. To accomplish this, Budget 2016 proposes to provide an additional $4 million per year to the Aboriginal Court Workers Program, which assists Indigenous peoples moving through the criminal justice system to better understand their rights and the nature of the charges against them. It also helps those involved in administering the criminal justice system to overcome language and cultural barriers when dealing with Indigenous peoples and to better appreciate the socioeconomic circumstances that they face. In addition, the government plans to reinstate the Court Challenges program, which I know this committee is studying, and provide $12 million over 5 years in financial assistance to individuals and groups who wish to clarify their language and equality rights in Canada's courts. When combined with the existing federal investments, total funding would be $5 million annually. Budget 2016 also provides $88 million over 5 years to increase funding in support of the provision of criminal legal aid in Canada, as well as $7.9 million over 5 years for the Courts Administration Service to invest in information technology infrastructure upgrades to safeguard the efficiency of the federal court system. Mr. Chairman, improving partnerships with provincial, territorial, and municipal governments, as stated in my mandate letter, is essential to deliver the real positive change that we promised Canadians. To that end, I met with my provincial and territorial justice and public safety colleagues earlier this year in January. I believe that meeting has allowed us to establish the partnerships we will draw on over the coming months and years in order to create a meaningful difference in the lives of Canadians. Canada's continued success absolutely depends on including multiple voices as we reevaluate our approach to important legislative matters such as marijuana legalization and regulation, reforming our criminal justice system, and most recently, legislation to ensure that dying patients who are suffering intolerably from a serious medical condition would have the choice of medical assistance in death. This work requires true partnership between the federal government, and the provinces and territories, which can only be achieved by sitting down together and engaging in open and continuous dialogue, sharing our knowledge, and bringing a range of perspectives to the table. However, perhaps the most challenging but most necessary area we need to focus on is rebuilding the nation-to-nation relationship that lies at the heart of Canada. The importance of this relationship to me and to this nation with respect to Indigenous peoples cannot be overstated. As you know, this is a priority of our government, and we are working to find long-term solutions in full partnership with Indigenous peoples as we develop a new framework for reconciliation based on recognition and respect. Mr. Chairman, in Canada, there is an unacceptable overrepresentation of Indigenous women and girls who go missing or who have become victims of violence. In line with our commitment to launch a national inquiry into this matter, Budget 2016 would allocate $40 million over 2 years to support this important work. Along with working with my colleagues on this inquiry, the Department of Justice, through its main estimates allocations for 2016-17, would be allocating $1.98 million to the government's action plan to address family violence and violent crimes against Indigenous women and girls, as stated in the main estimates. By providing important support for projects to break cycles of violence and for culturally responsive victim services, this program will help make Canada more just and inclusive for Indigenous peoples. As a steward of Canada's justice system, I take my responsibilities and accountabilities in this role very seriously. As a government, we have begun to re-examine what we do, why we do it, and how we can measure success. We are identifying what is working and what is not working and how we can best change it. The government intends to work in an open and transparent way with all of its partners to create an environment that will position us to best achieve the best possible solutions on these and other issues that affect the lives of all Canadians. For example, and as mentioned in Budget 2016, there are plans for consultations on a framework for the legalization of marijuana, with special emphasis on how to keep marijuana out of the hands of children and youth. My mandate letter also tasks me to review Canada's litigation strategy. As part of this review, we have already either discontinued appeals or I am reconsidering the Crown's position in many cases. This will ensure that the government's litigation positions are evidenced and principle-based, as well as consistent with the Charter of Rights and Freedoms, our commitments, and our values as Canadians. Mr. Chairman, just to return to the subject of the 2016-2017 main estimates, this funding will help our department to continue to provide the funding to programs such as the Victims Fund, the Youth Justice Fund, the Aboriginal Justice Strategy, that fulfill our mandate to ensure fair and accessible justice, a justice system for all Canadians. Finally, the Department of Justice is investigating ways to be more efficient. This includes constantly reviewing our effectiveness of our own business practices and systems. I'm pleased to report today that through our ongoing legal services review, we have decreased our budgetary requests this year by $3.36 million. And Mr. Chairman, as I stated earlier, I'm truly honored to be the Minister of Justice and the Attorney General for Canada at this incredibly important period in our history, and to do my part to give back to our country through public service. By continuing to report on our progress and to demonstrate openness and transparency in this matter and others, my department is helping to contribute to improving our justice system. We believe this will lead to better collaboration, better government, and greater success for Canada and Canadians. And I would like to conclude where I started in thanking the members of this committee, recognizing that each member has expertise in particular areas and will contribute substantively to the discussion that takes place at this committee. So I would invite any questions, comments that the committee members have. Thank you, Mr. Chair.
Thank you very much, Minister, for your very clear overview. We will go to a question period, and we'll start with the only person at the table who has been in your chair, Mr. Nicholson.
Does that mean to put pressure on me, Mr. Chairman?
It was exactly that.
Just checking, you know. But I'd like to welcome the
empathy,
Minister.
one of the two.
That's right. I'd like to welcome the Minister and thank you for your opening comments. And I know you will be well served by the Department of Justice, as has me and previous ministers here. You get great support in that role, and they play a great role in assisting this country on so many different issues. And so welcome to the committee. Thank you as well for, in your opening remarks, you talked about the Aboriginal Court Workers Program. I've raised this matter before. It was one of those programs that it seemed to me that was of great value to people getting involved with the court system and having people who have some insight into the challenges that some of these individuals have. And so I'm pleased. I think you said there's an increase of $4 million for that program. And I know I've asked this before, and it's one of those ones that I hope that you will continue to have, because the feedback on that is that it has been very, very helpful. One or two issues that I'd like to raise with you. You said in your opening comments that there would be an allocation that will accompany you said the legalization of marijuana. I wonder if you could clarify for that. It's not the same thing, of course, as decriminalizing. I've heard comments that marijuana will be decriminalized, which means it could still be unlawful to have, but legalization is something slightly different. I wonder if you could clarify. Is marijuana going to be legalized in this country or just decriminalized?
Well, thank you for the questions, and I too would like to acknowledge you as the predecessor in this role. And to the first point, acknowledging the work that the Native court workers across the country continue to undertake. The $4 million a year is a top-up, acknowledging the work that they do in assisting Aboriginal access to justice. In terms of, I just have a note here with respect to the court worker program. There are 176 court workers providing services to approximately 64,330 Indigenous clients in 435 communities. To your point with respect to our commitment on legalization of marijuana and strictly regulating access to marijuana, we are committed to ensuring that we take a comprehensive approach to the legalization, which would ensure that we decriminalize the use of marijuana while at the same time ensuring that we keep to our ultimate objective, which is to keep it out of the hands of children and keep the proceeds out of the hands of criminals. So I'm working with my colleagues, the Minister Ministers of Health and Public Safety to ensure, and Parliamentary Secretary Blair, to ensure that we put in place a comprehensive framework that will provide that regulatory framework to ensure that we achieve our objectives. These will go hand in hand, and we are very much looking forward to launching a task force of experts that will be engaged in providing recommendations around legalization and putting in place a regulatory framework with respect to marijuana. And those experts will include experts in the area of health, in the area of public safety, law enforcement, and justice.
Well, thank you very much, and my best wishes to Parliamentary Secretary Blair for taking on this role. Thank you, sir, for that. There is a program that has been in place since about 2009, the Supporting Families Experience Separation and Divorce Initiative. There's a decrease in this budget, and it appears that it may be sunsetted. Again, it was one of those programs that you know, those of us who followed this have had good reports back. I mean, what has been the advice that you've been getting on this? That have you found that it's no longer effective, or why would at this point in time would we be sunsetting something that up to this point in time I feel has been very, very helpful?
Well, thank you for the question. In terms of funding for Supporting Families Experience Separation and Divorce Initiative, the Department of Justice continues to provide legal policy advice, litigation support, and family enforcement for these services with the funds currently available. For example, as you likely know, with federal funding, the government has been able to garnish $188 million in federal monies to help satisfy family support obligations in 2015, 2016. All of this money ending up in the hands of families. We feel strongly that Canadians living through separation and divorce need to continue to be supported, and we will be working to ensure that we find ways to continue this work and find ways to best meet the needs of families that are experiencing separation and divorce.
Well, thank you very much, because again, the feedback on that it was helpful, and again, it answers you know, some of the challenges that we hear from people in that. Those are my questions, Mr. Chairman. Thank you very much.
And may I just congratulate you, because you finished exactly at 5:59 on your 6 minutes.
Well, you kept giving me the cutoff here, so I was assuming that was
Never.
no.
Never. Mr. Biddle.
Okay. Thank you, Mr. Chair. Thank you, Minister, for taking the time to answer some questions today. The federal court has recently ruled that the current manner in which the department applies Section 4.1 of the Department of Justice Act is constitutional, notwithstanding that the government has the right to revise the standard under which the section is applied. Do you foresee any change in this respect?
Well, I think that you're referencing this Schmidt case that came down. As all ministers of justice, take my responsibilities under 4.1 of the Department of Justice Act very seriously in terms of providing reports on whether or not legislation that's introduced are in compliance with the Charter of Rights and Freedoms, and we will continue to meet our reporting obligations. In addition to that, as minister, we have and will continue when introducing government legislation to provide an analysis or an explanatory paper of how legislation has been developed, as we have with respect to medical assistance in dying. And what I've instructed and what we are going to continue to do is to ensure that we, as much as possible, provide explanations to Canadians about the thinking and the considerations that have gone into legislation, the considerations or risks in terms of the Charter that may or may not exist with respect to a piece of legislation to invite parliamentarians, certainly, and Canadians into the conversation about public policy decisions and the reasons why public policy decisions have been made. So that's a commitment that we will continue to move forward on, not only with medical assistance in dying, but other legislation that's going to be introduced in the very near future.
Thank you so much. How do you see restorative justice fitting into the criminal justice system review?
Well, as all members know, I have been tasked by the Prime Minister to do a comprehensive review of the criminal justice system, including sentencing reform. We have and continue to plan all aspects of that review. And in terms of restorative justice, this is something that is a key priority for our department, for myself, looking at ways that we can take different approaches to the justice system, that we can look at developing programs or supporting programs that are more successful in doing as much as we can. One, for example, to reduce the overrepresentation of Indigenous peoples in the criminal justice system, look at measures such as drug treatment courts, community courts that seek to limit the what becomes, in a lot of circumstances, a revolving door of people that present themselves into the criminal justice system, but to develop off-ramps for people to ensure that hopefully their first encounter with the criminal justice system is their last. And this is a community approach that we need to take. This is an approach that we're committed to undertaking with the provinces and territories, with communities, to ensure that we support innovative projects and measures that will look to restorative justice, but also looking at initiatives that are preventative as well.
Thank you. The last government, previous government, introduced a number of mandatory minimum penalties in terms of the Criminal Code, Controlled Drugs and Substances Act. The legal community and the courts have been vocal in its opposition to these changes, and I saw as a lawyer myself the delays that then permeated through the entire justice system. What is your position on these types of penalties, and will you be looking at reversing some of these mandatory minimums, and can we see action on this, or will we see action on this?
The short answer is yes. A review of sentencing over the past 10 years is a key part of my mandate in terms of the broader criminal justice system review. We will be looking at the mandatory minimum penalties that are in place in the criminal code. I will say that our government is not opposed to mandatory minimum penalties for the more serious crimes, but our review will ensure that we respect decisions of the Supreme Court of Canada and that we ensure that sentencing provisions are in compliance with the Charter of Rights and Freedoms. And this is an undertaking that is going to take a bit of time, but we are looking at being able to approach mandatory minimums in potentially an incremental way, so we can see some changes as we proceed through the course of our mandate.
Thank you very much. Mr. Rankin.
Chair, and thank you to Minister Wilson-Raybould, and thanks for coming back with your officials. I wanted to ask about 2 or 3 things in the time available. The first, I think, on marijuana possession, building on Mr. Nicholson's question. We heard testimony on March the 10th from the Public Prosecution Service that the government plans to spend $3 to $4 million each year prosecuting charges of simple possession of marijuana. That's 2 to 3% of what the PPSC plans to spend overall for its program on prosecution of drugs, criminal code, terrorism in the coming year. At the same time, Justice Selkirk of the Ontario Court of Justice, in a case called Racine, refused to accept a guilty plea to possession of marijuana. He said, quote, "I recall distinctly the Prime Minister in the House of Commons saying it's going to be legalized. I'm not going to be the last judge in this country to convict somebody of simple possession of marijuana. You can't have the Prime Minister announcing it's going to be legalized and then stand up and prosecute it. It just can't happen. It's a ludicrous situation, ludicrous, close quote. So given these costs, concerns expressed by our judges, and your government's intention to legalize marijuana, have you as a minister considered calling a halt to further prosecutions for simple possession of marijuana?
Well, thank you, Mr. Rankin, for the question, and it certainly has been marijuana generally and its legalization has been a subject of much conversation right across the country, certainly including within the walls of this place. As I said earlier, our government is committed to the legalization of marijuana and strictly regulating access to marijuana with the ultimate objective to keep it out of the hands of children and keep the proceeds out of the hands of criminals. With respect to decriminalizing marijuana right now, I think our Prime Minister has spoken very clearly around this, and in doing so would not achieve our ultimate objectives as I just described. But what we are committed to doing, working certainly with Parliamentary Secretary Blair, is to take our time to put in place the complex framework that is required, and engaging with experts on a task force to provide recommendations, engaging with Canadians on this discussion, and knowing that until such time as marijuana is legalized, current laws will continue to apply, and looking to law enforcement agencies to do, and I certainly respect the jobs that they need to do in their various jurisdictions.
The consequence of that is kids will still be going to get criminal records or records that will affect their employment and their ability to travel and so forth at a time before your government gets its consultations completed, and their lives will continue to be dramatically affected by something that will be perfectly legal a year from now. I just wanted to, that's the consequence of what you're saying.
Well, the reality is that we need to ensure that we take consideration of all issues that come before us in terms of ensuring the safety of products that are available, ensuring that we work on the health-related aspects and public safety aspects. But this, your questioning and other questioning highlights the need to ensure we're moving as quickly as we can on this, and ensures that we, as parliamentarians and as a government, move forward and put this complex regime in place, but to ensure that we do it right.
Right. Minister, on April the 28th, I was in Edmonton. I met the President and CEO of Legal Aid Alberta. She said the situation for funding is desperate. She said the federal funding of $10.4 million of their total $68.5 million budget has been static for 8 or 9 years. And despite increasing population in that very young province, despite the urban Indigenous population growth, despite the Daniels case and its impact, they're calling out desperately for federal help. I note that you are underway an evaluation of the legal aid program started in 2015 and is expected to be completed in October 2016. A particular irritant is that they only get $500,000 a year for immigration, an area of exclusive federal jurisdiction. They spend way more of their own funds for that. So my question to you is, we're talking about access to justice in this committee. Can you give any comfort to Legal Aid Alberta and other legal aid plans that help is on the way?
Well, I appreciate the question, and without question, legal aid provinces and territories have not seen increase in legal aid funding since 2003. I'm very pleased that in our budget, $88 million has been allocated to support legal aid, and I've met with my counterparts in the provinces and territories and understand the need in each of those provinces and territories, including Alberta. And we are in the process of working with the provinces and territories to see how the monies can be best allocated, having regard to the increase in population, as you mentioned, but also, and this has come out very loudly and clearly from provinces and territories who have, with limited monies for legal aid, have become very innovative in terms of their programming. And that's not to say there isn't a need for additional monies, but to ensure that we are working with the provinces and territories on these innovations that they have, and ensuring that we provide the necessary resources to the provinces and territories, including Alberta.
Time, Chair?
You're sort of out of time, Mr. Rankin, but you'll get another round.
Okay, thank you.
By the way, we are doing a review of legal aid after we finish our court challenges study and the access to justice study, so we'll have a chance to talk about that. Mr. McKinnon.
Thank you, Chair. Thank you, Minister, for coming. I'd like to talk about the overrepresentation of Indigenous peoples in our correction systems. Given that the government has indicated its intent to extend the Aboriginal Justice Strategy, in which ways is the Department committed to ensuring that the GLADU provisions are effectively applied?
Well, I thanks for the question, and in terms of our review of all of our programming and finding and identifying measurables to see if we're being successful, I think the overrepresentation of Indigenous peoples in the criminal justice system is a key measurable. Obviously, the objective is to reduce that number. We will be looking at the overrepresentation of Indigenous peoples, their interaction with the criminal justice system in our broad review of that system, including sentencing. In terms of the Aboriginal Justice Strategy, we are supporting many initiatives under that strategy, and just in terms of some statistics, with respect to the Aboriginal Justice Strategy, 89% of the program participants successfully completed the Aboriginal Justice Strategy program and therefore were not incarcerated for the offence. 68% of the program participants had not reoffended 8 years following participation in the Aboriginal Justice Strategy. I think that there are many initiatives in Indigenous communities in various areas in the country that have presented substantive options for restorative justice, for preventative justice for Indigenous peoples in the country. All of these initiatives will be included in our broad review of the criminal justice system. At the same time, initiatives like the Native Court Workers will also assist in this regard. But broadly speaking, our government is committed to a nation-to-nation relationship with Indigenous peoples and looking at various mechanisms and means to embark on or go down a path of true reconciliation. All of this together will contribute to improving ultimately the lives of Indigenous Canadians and working in partnership with them on solutions that work. And that includes ensuring where an Indigenous person and GLADU principles are applying to an Indigenous person in terms of sentencing, that those measures are in place and that we ensure that we continue to support initiatives that reflect the realities and the individual circumstances and cultural appropriateness of Indigenous offenders.
Thank you. I should have asked this first. So 13 years after GLADU in Regina versus IPLI, the Supreme Court of Canada revisited the decision and found that statistics indicate the overrepresentation and alienation of Aboriginal peoples in the criminal justice system has only worsened. Do you have any thoughts on why that might be? Is it because the Gladue principle is not being applied effectively, or are there other factors at play here?
Well, I think that there are many reasons why the numbers in terms of Indigenous peoples in the criminal justice system are not improving. I believe, and our government is committed to ensuring that we build and foster a substantive new relationship with Indigenous peoples that's based on a nation-to-nation relationship, and that we identify and build a reconciliation framework that takes into account all of the various tools that would assist in defining our relationship with Indigenous peoples, specifically working in partnership where Indigenous peoples put forward solutions to assist in moving forward with jurisdiction or moving forward with programs and services to ultimately improve their communities, that we support those initiatives. I think in terms of looking at the criminal justice system, there are ways that we can improve the criminal justice system as it respects or engages with Indigenous peoples, but we also have to, and this speaks to the work that we're doing on the Murdered and Missing Indigenous Women's Inquiry, speaks to the work more broadly in terms of Indigenous peoples, that we need to look at the root causes of why the situation exists in the first place. Indigenous peoples, and I think this is true generally, there are many reasons why people present themselves in the criminal justice system. Root causes such as marginalization, such as poverty, the lack of housing, education. We need to ensure that we're addressing those root causes of why the situation exists in the first place. And we're committed to, with respect to Indigenous peoples, working in partnership to address those issues.
Thank you very much, Mr. McKinnon. So we're now going to go to the second round of questions. We have another 25 minutes with the minister because she has to leave at 9:30. So what I'd ask in the second round is if everybody could take 5 minutes instead of 6 minutes, so we make the round. Just for everybody's so that everybody remembers, the second round goes Liberal, Conservative, NDP. Okay, so we're going to go to Ms. Khalid. Ms. Khalid.
Thank you very much, Mr. Chair, and thank you, Minister, for coming in today. It's definitely appreciated. I do have a couple of questions. The first pertaining to your ministerial letter. Last month, I did a night shift ride-along with the police in my riding, and one thing that I realized over the course of the night was that about 1 in 3 calls for 911 in the local area dealt mainly with mental illness. And I see that in your mandate letter that you are seized to do something about the problem that we have with mental illness, specifically with respect to our justice system. And I'm wondering if you can shed some light and share what kind of initiatives that we'll be taking, and the Department of Justice will be taking with respect to that.
Well, thank you for the question, and I think it's I'm glad to hear that you went on a ride along. I think that it's an important learning experience for many people to do just that. In terms of mental illness, I'm working with the Minister of Public Safety, looking at the recommendations that came out of the inquest into Ashley Smith. Certainly this deals with solitary confinement, but also speaks to mental illness. We are going to be working jointly on looking at those particular recommendations, and that work continues. But also it speaks to the varying reasons why people present themselves in the criminal justice system generally, whether it be for poverty reasons or marginalization, as we talked about, or people that are suffering from addictions or people that are suffering from mental illness. We have to do better to identify the reasons why people are in the situation, and to work with my colleagues across the provinces and the territories to ensure that we identify those reasons, and that we work in a community approach to develop where there aren't any, or to create and encourage those off-ramps, so we can ensure that we're addressing the specific circumstances why an individual comes into the justice system. So in the case of mental illness, that we provide the necessary supports and services for those people, and that is definitely something that we're committed to ensuring that we move forward on, working with my minister colleagues who are directly impacted and have responsibility in these areas as well.
Thank you for that. I'm really looking forward to those solutions. Secondly, as you may know, over the past many weeks, we've been working on hearing witnesses' testimony about the Court Challenges program, and seeing how we can use the $5 million per year budget that has been allotted for this program. And now we will be coming up with recommendations very soon, and we're hoping that yourself and the department will take our recommendations into account when we go ahead and develop this program. And I'm wondering if you can commit to reviewing at least our recommendations that we provide.
Well, as you pointed out, this was a commitment in not only my mandate letter, but the mandate letter of the Minister of Heritage. And we're working collaboratively on the Court Challenges program. And I know that our officials from our department appeared before this committee. And I would commend the study that this committee is undertaking with respect to that program. And I live by the philosophy that in order to achieve the commitments and do the best job we can in achieving those commitments, we need to embrace the expertise and the diversity of opinions that exist around this committee table, that exist out there across the country. So I very much look forward to the recommendations that this committee will bring to the Court Challenges program, and how we can ensure that the monies that are being allocated to that program are used most effectively. So I'd welcome those recommendations, as well as other recommendations that the committee and studies that the committee wants to undertake.
Thank you very much. Mr. Cooper.
Thank you, Minister, and welcome back to the committee. I appreciated your presentation this morning. I have a couple of questions. The first issue that I want to raise is one that I've raised before in the House of Commons, and that is judges. Our courts face a serious backlog. I guess that's not new, but it is, I think there would be agreement that it's been worsened as a result of the fact that there is a large number of judicial vacancies. At this time, it looks like there's at least 46 vacancies across Canada, and yet not one judge has been appointed. Yesterday, in response to a question that I asked you in the House of Commons, you referred to short-term procedures that were in place to deal with this, and I was wondering what those short-term procedures are.
Well, thank you, Mr. Cooper, for the questions, and know that that you will continue to ask me questions about judges until judges are in place. As I said yesterday, and will say today, there are, as you point out, a substantive number of vacancies across the country in our courts, and one, in terms of a comprehensive review of how judges are appointed, and ensuring in my my review and appointment process that we not only look to merit, but we also look at diversity. And that's part of the broader process of appointments that I'm committed to undertaking, and that work is underway. In terms of the shorter, and I'm not sure appointment process is necessarily accurate. I may have said that yesterday in the House, but I know that in speaking with Chief Justices across the country that there are urgencies in all appointments are urgent, but there are some that need to be filled sooner than the broader appointment process. So in terms of that shorter appointment process, again, I am engaged and have spoken to Chief Justices across the country. I know that there are lists of potential justices that can be drawn from, and we're reviewing very closely those lists of persons, ensuring that we reach out and engage with stakeholders, and that includes the judiciary, to fill those more urgent positions in the short term. And I again will say that those appointments will be coming as soon as possible, ensuring that we have done our due diligence in reviewing those names.
Well, thank you, Minister, and it certainly seems like it has become quite urgent when we see, for example, in Alberta, a serious fraud case thrown out. It looks like this week perhaps 2 sexual assault cases may be thrown out for delay, so I would just reiterate the urgency is now. But I appreciate the answer, and just turning to a different topic with the remaining time that I have, the June 6 deadline that the Supreme Court issued in terms of the stay on the Declaration of Constitutional Invalidity is coming up, and obviously the Bill C-14 is moving forward in the House of Commons. But in conversations that I've had with Senate colleagues, there seems to be a general consensus from those that I've talked to that the legislation may not get through the Senate by the June 6 deadline. So in that scenario, what steps is the federal government going to take? What are you going to do as minister? Or would, for example, you consider bringing forward an application to the Supreme Court for a short-term extension to allow sufficient time to make sure that legislation can get passed before we end up in a situation where there could be a vacuum with no law and no certainty for physicians, for patients, and no safeguards for the vulnerable?
Well, thank you for that question. And again, I would look around the table and thank all members of this committee for the substantive discussions that have been had around C-14, medical assistance in dying. To your question, the June 6 deadline of the Supreme Court of Canada is incredibly important, and our government is committed to doing everything we can to meet that deadline. Recognizing where the proposed legislation is within the House of Commons, acknowledging the substantive work that senators have done in their pre-study phase, and recognizing the work that they will continue to do in considering Bill C-14. I would stress, again, the importance of meeting the June 6th deadline. We are doing everything that we can to ensure that that is the case. Not meeting the June 6th deadline, as you rightfully point out, would leave a vacuum. It would leave, in terms of the law, in terms of the application of medical assistance in dying in this country, around eligibility, the court application process for exemptions would no longer exist. There would be no safeguards in place. Medical practitioners would have uncertainty around how the Carter ruling would be applied. And I think further to that, in terms of patients that want to access medical assistance in dying, they would be limited in doing so given the uncertainty that would exist. And as you know, in this country, the only jurisdiction that has a law around assistance in dying is in Quebec. So I am very committed to ensuring that we do what we can, everything we can to meet that June 6th deadline.
Thank you very much. Mr. Sen?
Good morning, Minister. I just want to quickly take the opportunity to thank you for coming and addressing the committee and to also coming back again to meet with the committee. My question has to do with bail, with remand custody. There has been an increase in individuals who have been in remand custody over the years, and the numbers have gone up, and I can attest to my practice as a criminal defense lawyer over the years that was the case, and the numbers that were presented to the committee in the beginning by the Department of Justice officials showed an increase in the percentage of individuals who are in custody. What are the department's plans to address that, and is there any money that is set aside to address the increasing numbers of people who are in remand custody?
Well, thank you for the question, and certainly reviewing bail and the regime will be part of our overall review of the criminal justice system. We are in the process and will continue to undertake a comprehensive review of the realities in terms of remand, in terms of bail. A broad review has not been done since 1972. And we're committed to engaging with the provinces and the territories on this. Would look to members of this committee, but look to experts and impacted persons in the defense bar with respect to Crown Counsel to understand the issues and to respond accordingly and to renovate the bail system in this country. That's a commitment that we've made.
Thank you. The other question I had has to do with the legal aid program. Again, this is an area that is something that a lot of the provinces are seeking leadership and help from the federal government. The Department of Justice's report on plans and priorities for 2016-2017 aims for 270,000 approved applications for criminal legal aid in the provinces between March 2016 and March 2017. How would this goal, this achievement, compare to performance indicators in previous years? The goal of covering 270,000 applications in this fiscal year.
Maybe I'll answer that question, sure. Mr. Chair. Thank you for the question. The first thing it points to is that we are trying to determine real live outcomes for Canadians in terms of the programs that we're delivering, and that is one metric. I should say that metric was delivered before the budget decisions had been announced, and so it does not take account of the additional funding that will flow over the coming years, and we frankly will be looking to adjust the metric in terms of number of approved applications and other outcomes that we can measure with the additional resources. So it would be comparable, I believe, to prior years in terms of what we were trying to achieve with the resources. We will be reviewing all of that in light of the additional money. We haven't had new legal aid money to consider since 2003, so we'll need to adapt in terms of what we're planning to achieve with the additional resources. And we're in discussions right now with provinces and territories to try to determine both how the money is allocated and what we can expect to achieve with it.
Okay, thank you. Do I have
you have a short question?
So just a short question on the departmental review from 2013-2014. Just if you can quickly give us an idea of what the results of that review were.
The legal services review?
Yes.
In light of continuing pressures, increasing litigation loads, increasing legal risks, the department looked at a future where continued growth didn't seem like the best solution. And second, like the rest of the legal industry, realizing that there's opportunities to use technology better, we undertook a review to try to see the ways in which we could manage pressures within our existing envelope. And so we've tried to achieve efficiencies in a number of ways. I'll give you one very concrete example that will resonate with all of you. If you were to get involved in a lawsuit today, and the request was made for you to disclose all of your electronic records related to that matter, you would look in your emails and find draft, final draft, draft, final draft, draft. You would find a whole series of reply all discussions around a particular case, and very soon you would end up with tens of thousands of electronic records that need to be sorted through. We work in government. That's what we do. We're familiar with government systems. We've developed now an electronic tool that we funded and developed internally, and a team of paralegals that have become much more efficient at, first of all, going to the end of all that email chain, eliminating all the duplications, grouping like materials together. So we're now doing document review and disclosures in a way which I would say is between 8 and 10 times more efficient than we were before, simply by better use of technology, better harnessing of people, and being sensible about it. We're asking our lawyers to devote more of their working time to delivering legal services for clients. We're looking at trying to make sure that when there's a legal issue that touches 4 departments, we don't have 4 lawyers working on it, we have 1. So those kinds of efficiency measures, we're trying to look to the outside to see what the private sector is doing, apply it internally, and drive efficiencies in how we deliver services. And I'm proud to say that with the work of great professionals from coast to coast to coast, we have found significant ways of delivering more efficient legal services and still delivering outstanding outcomes for Canadians.
Thank you very much. Mr. Nicholson.
Thank you very much, Mr. Chairman. I just want to raise a comment that was made earlier on this, and we'll probably be able to get into this when the Public Prosecution Service is here and Brian Saunders can ask this. But my colleague in the NDP said that he was concerned about time the Public Prosecution Service was prosecuting kids for possession of marijuana. Just to be clear that any changes that the government does bring forward in this, it's still going to be illegal for children to have marijuana. That's correct, isn't it, Minister?
Correct.
Thank you very much. With respect to the questions that my colleague asked on judicial appointments, you would have in your office the dozens, if not hundreds, of individuals who have been cleared by the judicial advisory committees. And I mean, these judicial advisory committees in every province are made up of representatives from the Bar Association appointed by the province. I mean, they have a wide range of people. I mean, wouldn't it be possible for you to make a number of appointments of people who have been recommended by the judicial advisory committees? I mean, ultimately, this is the prerogative of the Crown to make these appointments until such time as you come up with another system. I mean, you've been in office now about 7 months, and perhaps to some of us it seems longer than it might otherwise be. But that being said, wouldn't it be possible for you to make a number of these appointments, particularly in some of these provinces, and like my colleague pointed out, in Alberta and some of them, until such time as you come up with another system?
Well, I appreciate the first clarification with respect to marijuana in children, and to your point about 7 months going by slowly, it's gone by quickly from my perspective. But having said that, take very seriously the concerns raised by members here with respect to judicial appointments, and we do have lists in terms of persons that have been recommended by the JACs and are very considered in reviewing those lists and ensuring that we engage stakeholders, including the judiciary, in terms of making substantive decisions around that shorter-term appointments that will be made. So I take the point and recognize that we have resources at our disposal in terms of suggested lists.
Thank you.
Passing to Mr. Falk, you have another
Thank you,
2
Mr.
minutes.
Chair, and thank you, Minister, for your attendance and your presentation here this morning. The Prime Minister committed that your government would avoid any appearance of conflict of interest, and in fact, he said that was a standard that he would maintain. And I would just like a little bit of there have been some accusations over the past that perhaps that standard hasn't been adhered to. I'd like your comments a little bit on what that means to you and what that would look like. in your role as Minister of Justice?
Well, I obviously can only speak for myself. I, as the Minister of Justice and the Attorney General, as well as a Member of Parliament, take my responsibilities in terms of meeting conflict of interests and ethics standards, and hold those standards very high, and am committed to ensuring that I meet my commitments on an ongoing basis with respect to those standards. As such, in all activity that I undertake as the minister, I ensure that I continue to work very closely with the Conflict of Interest and Ethics Commissioner in terms of my activity, and ensuring that I follow her direction very closely. But again, I would assure this committee, as I would assure all Canadians, that I take these responsibilities incredibly serious, and I would not seek to do anything that would undermine the position that I hold, and ensure that all matters and necessary procedures are followed to ensure that I am abiding by all rules.
Final question, Mr. Rankin, and then we'll let you go, Minister, but we have one more round.
Thank you. Just one question, and thank you to Mr. Nicholson for allowing me to clarify. When I said kids in that question, of course, I didn't mean to suggest anything to the contrary. Of course, children will still be subject to marijuana laws. I guess I was reacting by saying that to young Canadians, because I get letters from parents all the time about the injustice of the situation we're currently facing, and at what Mr. Justice Selkirk called the ludicrous situation that exists. So thank you for letting me clarify that. C-51. I want to ask if you could comment on the scale of your department's spending in relation to implementing Bill C-51. The estimates for Justice Canada included an additional $6.8 million for activities relating to Division 9 of the Immigration and Refugee Protection Act, which is, of course, the security certificates part, and more than half of the $8.4 million increase over last year's main estimates for the Court Administration Service relates to these proceedings. I just want to know, number one, what impact has Bill C-51 had on the number and cost of these proceedings? And more broadly, could you comment on your spending in relation to C-51 implementation?
Well, I would like to defer that question to the Deputy to respond.
So the spending, as the question indicates, is in respect of Division 9 security certificate and related closed proceedings. It does not relate to the administration of C-51. Security certificates have been a part of the regime and have been evolved in accordance with Supreme Court decisions and practice over a number of years. Part of that evolution required the appointment of special advocates to advocate and challenge in these closed hearings. That's what that money relates to. So it relates to the legal advice and support and litigation support for Immigration and Canada Border Services Agency. It also relates in part to spending for special advocates. So
but you also, in your report on plans and priorities, you're going to be providing legal services in support of C-51. So just generally, how much is that going to be?
And I'm sorry, I don't have that particular figure. That will depend on the demand for legal services in terms of various activities relating to C-51. We certainly have been allocating some resources, for example, to training both departmental officials and others around the rules and guidelines and procedures that the law requires in respect of information sharing, for example. But we will be able to report next year on how much we've spent in terms of implementing C-51, but right now it's in a sense anticipatory.
Thank you. Thank you.
Thank you very much, Minister Wilson-Raybould. Thank you so much for joining us this morning. We really much appreciate it, and we'll break to have the next panel come on up.
Thank you very much. Thank you.
I'd like to thank and welcome our next round of witnesses, and I note that we've been joined by Elizabeth Hendy, who is the Director General of the Program Branch of the Policy Sector, and Brian Saunders. And Brian, I can't remember for the life of me what your title is.
Director of Public Prosecutions.
Thank you. Director of Public Prosecutions. And George, I can't remember your title either.
I'm a Deputy Director.
Deputy Director, thanks.
And I'm the other Deputy Director.
Excellent. I prefer the other deputy. That's an excellent way to explain it. Ladies and gentlemen, given the circumstances, at 10 o'clock, both Mr. Cooper and Mr. Rankin need to be in the House. So what I thought we'd try to do is we do one round of questions and see if that is sufficient for everyone, and then vote on the estimates so that we can get our members to the House on time. The first round here goes to the Conservatives. I'm not sure who is going to be asking the questions. Mr. Falk?
No, I wasn't anticipating.
Oh, I'm so sorry.
So quickly.
Mr. Cooper?
I don't have a question.
You don't have any questions?
No,
let's go to the Liberals first. Mr. Fraser?
I don't have any questions.
Let me just ask. Are there members present who have questions? And I'll just go to you.
Sure.
Mr. Rankin.
Thank you. I've always got questions.
You always do. You're always
not only good, not very good ones, but Mr. Cooper, you were here, I know, when he asked questions about the judicial appointments crisis facing some of our jurisdictions. And I want to ask about a different problem. That is the specific claims tribunal and the administrative tribunal support service. Now, we've been hearing from the Assembly of First Nations that tribunals like the specific claims tribunal are suffering from a shortage of judges, just like so many of our superior courts across the country. And yet the voted estimates for the administrative tribunal support services show a $3.4 million decrease due to the sunsetting of funds for that very tribunal. So are the measures we see in these estimates sufficient to solve the current problems with judicial appointments? And if not, what other action are you taking to correct these issues?
Mr. Chairman, I believe Marie-France Pelletier from ATSSC will be able to answer that question.
In relation to the funding decrease for the Administrative Tribunal Support Service of Canada, or ATSSC as we call it for short, there is a decrease in funding that is related to sunsetting of funds for the specific claims tribunal. However, the supplementary estimates A were recently tabled, and they contain the amounts that were to secure the funding for this fiscal year. So in the supplementary estimates A, you will see the amounts for the funding for the specific claims tribunal.
And can you?
Because we're having trouble picking up. So everybody, if you can all try to speak into microphones, we'd much appreciated. Mr. Rankin, sorry, over to you.
So in light of what you've just said about the supplemental estimates, so there's a $3.4 million decrease to the of funds for the specific claims tribunal, and the AFN has been very concerned about the lack of judges. You're saying that the supplementals are going to, because I haven't got that number in front of me, are going to address that perceived problem?
They will address the issue of funding for this fiscal year for the specific claims tribunal at a similar level or at the same level as it was funded before. Now, in relation to judicial appointments, for that tribunal, the ATSSC is not directly involved in the judicial appointment process to the or to any appointment process to any of our tribunals. However, this funding, should appointments come forward, should be able to allow us to properly address it.
Mr. Penny?
And just briefly, I can say on behalf of the Minister that as in respect of her earlier question in relation to judicial appointments, as you know, the appointments to the specific claims tribunal are a bit different because they're of sitting judges, and but the Minister is equally seized with the importance of ensuring that the specific claims tribunal vacancies are addressed, and has taken steps to try to ensure that.
All right. Another question?
For another question, yeah.
PPSC. The biggest increase over last year in the main estimates for PPSC is an increase of $11 million to pay anticipated commissions to private collection agencies for the collection of federal fines. Should these commissions not be offset by more efficient fine collection? And in terms of the actual, not expected effect of outsourcing collection, can you show a net benefit?
We changed the model of collecting federal fines a few years ago. We used to collect the fines using staff, members of staff of the PPSC. We decided that our ability to collect fines was limited by the amount of staff we could dedicate to that task. And we decided, therefore, to try using a private collection agency, which has been used in some provinces to collect outstanding fines. We went and did a process whereby a private agency was selected. And to fund the commissions that the agency will collect, that's $11 million that is you just referred to in the budget. That is $11 million last year. I believe it goes down to $8 million this coming year, and it stays at that level, I think, for a few years. And the idea is that money is flow-through money. It's not money in our budget. It's money that's to pay the private collection agency for collecting federal fines. They get 12% of every fine they collect. So the idea is that we'll see whether this will enhance our ability to collect the outstanding federal fines.
I guess my question, therefore, would be, are you doing a cost-benefit analysis? Will you be able to determine whether that expenditure is actually producing a positive effect or not?
If I may, we've issued a 2-year contract at the moment, and towards the end of that 2-year period, we'll be in a position to assess whether the private service provider is able to collect more than we were. We'll have something to compare to. I think even by the end of the first year of operation, we started in April of this year, we'll have a sense of how that's going, and it'll give us a chance to look at what model we want to adopt going forward. Certainly the expectation is a private service provider is going to be able to recover more than our staff could, but if that's not the case, then we'll give ourselves probably a year to re-examine it.
And was the private service provider chosen after a typical RFQ type of process? Thank you. Yeah. That's all.
I have Ms. Khalid and Mr. Falk, and then I don't have anybody else, so you'll let me know if you want to ask anything after that. So I think, well, in terms of the order, I saw the hands, Ms. Khalid and then Mr. Falk. Ms. Khalid?
Thank you, Chair, and thank you, Mr. Falk, for the generosity. My question is for the Public Prosecutions Department. Now, the 2016-27 main estimates, they provide for expenditures of $135.1 million for the Drug, Criminal, Code, and Terrorism Prosecution Program. I'm wondering if you can provide us with a breakdown of the amounts allocated to each.
Yes, I'll ask Mr. Dolai to answer that question, as he is in charge of that particular branch of our organization.
Thank you. As you indicated, approximately 135 is the total amount for that branch. It includes the 3 portions. The national security portion, we this year will have spent in excess of $4.3 million with respect to those matters. Those include both terrorism prosecutions and prosecutions under such acts as the Security of Information Act. Then with respect to the North, we have in the order of 55 prosecutors, pardon me, in the North, and that budget is approximately $10 million to $11 million, I believe, and then the remainder is for drugs. Pardon me, $20 million for the North.
Thank you. And just as a follow-up, do you have any statistics with respect to the terrorism-related work, such as the number of hearings that we've had, number of convictions, number of, well, basically prosecutions?
Yes. Yes, I do. With respect to the number of accused who have been charged with terrorism-related offenses since the Act came into place in December 2001, we've had 52 accused, 20 have been convicted, 1 has been acquitted, and we've had stays or withdrawals of 8, some of which have resulted then in peace bonds being imposed. We have proceeded to trial, both completed or underway, including guilty pleas. 21 have been completed to date. We have 2 underway right now. We have 9 accused for whom warrants are outstanding. In addition, we have the peace bonds, and peace bond applications have been made in respect of 19 accused. 10 have entered into peace bonds to date, 3 were withdrawn, and 6 are pending. Some of those that are pending relate to persons who are charged, because in a number of instances it began with a peace bond. There's then a charge under the Act that is the subject of a prosecution, and the peace bond hasn't been withdrawn at this point. The application, it would depend in part on what the result is during the course of the trial, including the assessment of the evidence by the trier of fact and our assessment afterwards.
Thank you. And one last one, just in line of that, do you think that the funding that has been allocated is enough for specifically the terrorism-related offenses?
The answer is yes.
Okay.
Thank you, Mr. Chair. And I just wanted to ask one question about the Victims' Bill of Rights. Can you tell me what the role of the Ombudsman for the victims of crime would be?
Don or Elizabeth?
Thank you. The role of the Ombudsman with respect to the Victims' Bill of Rights, when the government was developing the legislation, she was consulted. She had a number of proposals with respect to the legislation. The government considered those, and Parliament considered them. With respect to implementation of the Victims' Bill of Rights, there is allocated in the budget 8.79 million. Most of that money is going to the provinces, as well as police for training, to inform Canadians about their rights under the Bill of Rights. There's also training with respect to police officers, so that they understand the Victims' Bill of Rights, because quite often the police are the victim's first contact with the justice system, and it's important that the justice system actors understand. The Victims' Bill of Rights really is a cultural change, and that really requires a lot of culture change by the actors, the police, the prosecutors, judges, with respect to recognizing that Parliament has provided legal rights to victims, which they never had before in terms of provision of information, protection services, etc. The ombudsperson, with respect to the Victims' Bill of Rights, she has, under her mandate, will continue to have the mandate to hear complaints from victims and other individuals with respect to any federal government service, such as the RCMP or the Public Prosecution Service, with respect to any alleged violations of the Victims' Bill of Rights or other concerns. And so her role continues as it was before, but it has increased, of course, because now there is a new piece of legislation that needs to be implemented.
Okay, thank you.
Thank you very much. Thank you very much, Mr. Saunders. Part of the challenge that you have had over the years in terms of running your section of the department, or your department, is the staffing and hanging on to prosecutors. And there are a number of reasons why there have been some issues there. I wonder if you could give us an update on the staffing within the public prosecution, the actual prosecutors on the ground. Are you holding on to them? Are they staying? What are the challenges you've had?
You're referring to when you were in office, the problems that we faced in some regions where our salaries paid to federal prosecutors fell behind those paid to the provinces. And there were, in some regions, we were losing prosecutors to provincial prosecution services. A few years ago, a collective agreement was entered into between the association representing federal prosecutors and the Treasury Board, which provided for an increase that brought federal prosecutors up to a level that consistent with that being offered by the major provinces. Since that time, I think it's fair to say that we've been fairly successful in retaining our experienced prosecutors.
I'm pleased to hear that. I've got another second here. Just on the question of grow-ops, I used to hear for years from prosecutors and from police that the proceeds from grow-ops weren't just to supply the domestic market, that in many cases this was the currency to bring in more serious drugs into this country, the heroin, the cocaine, and other. And this was the currency that was being used. What have you heard? Has this continued to be the case?
Mr. Nixon, I'm happy to answer with respect to the use of the marijuana. There is still an exchange component to it for other drugs, and there's historically also been in certain parts of the country an exchange for firearms in the United States, where the firearms are cheaper there. The marijuana is more expensive, and so it's been used as a currency in that respect as well.
So it's the currency for hard drugs and firearms, and so presumably those customers of the grow-ops would be pretty pleased about the new legislation coming in that will be legalizing this and expanding the supply in Canada. Maybe you are not in a position to answer that question, or maybe we'll maybe take that as a comment. But thank you very much for all the work that you do. Thank you.
Okay, Mr. Fraser had wanted to ask a quick question.
Thank you very much. Just with regard to the administrative tribunals, and I'm not sure whose competency this would best fall within, Madame Pelletier, with regard to the Social Security Tribunal of Canada, I know that the Auditor General in 2015 had identified that there was quite a backlog of cases pending appeal, and that started, I guess, when the Social Security Tribunal was set up in 2012, basically doubling effectively the number of appeals that were in the system backlogged. Wondering what steps have been taken since this has been identified by the Auditor General, and what comment you would have with regard to fixing that problem.
Thank you, excuse me. Thank you, Mr. Chair. Indeed, we just actually recently appeared before the Public Accounts Committee along with the department and the tribunal to address the report of the Auditor General and its findings. What I can say is that even since the Auditor General's report or his study concluded, which was back in May of 2015, there's been a tremendous amount of progress in relation to reducing that backlog, and indeed the historical backlog, meaning the cases that had been transferred by the Legacy Tribunal on day one of the operations of the Social Security Tribunal, has all but been eliminated. I think as of a few weeks ago, they were down to about 25 cases that were left, but also in progress. So it's possible that has moved even further since then. So the efforts now, of course, are to ensure that there's always improvements to reducing the caseload inventory for that tribunal, and they're very much engaged in that, and as well in responding to the recommendations from the Auditor General. Excuse me. And of course, as a support service, we are hand in hand with the tribunal to assist them in making progress on those fronts.
Is there anybody else that had any questions for the panel? Y a-t-il des questions? Monsieur Rankin a déjà demandé des questions avant qu'il ait quitté.
Any questions? Mr. Rankin left, so welcome, Madame Laverdière. I believe this is your first time at our committee, so it's a pleasure to have you with us. I'd like to thank all of the witnesses. It was a pleasure for us for talking to you.
Our colleagues get up. We have the votes that we need to take on the mains. So colleagues, I'm going to read out different questions, and I'd appreciate. Oh, that's okay. Don't worry about it. I'd appreciate if you would vote yay or nay. So vote number 1 under Administrative Tribunal Support Services of Canada, carry. Those in favor? On division. On division. Shall vote 1 under Canadian Human Rights Commission, carry. On division? Non-division. Division? Okay. Shall vote 1 under Courts Administration Service, carry. Also on division? Shall vote 1 under Justice, carry. On division? On division. Shall vote 5 under Justice, carry. On division? Shall vote 1 under Office of the Commissioner for Federal Judicial Affairs, carry. On division? Le crédit numéro 5 sous la rubrique Bureau de commissaire à la magistrature.
Vote 5 on the Judicial Commission. Shall it pass? On division. Vote number 1. Director of Public Prosecutions. Is it adopted? On division.
Canada carry on division.
On division, yeah.
And may I report the main estimates 2016-2017 to the House?
On division.
Oh, sorry. Oh, that's also on division. Okay. Thank you very much, colleagues. I very much appreciate your attendance. Meeting adjourned.